Aloha, everyone. This is so exciting to be here today for another CJS seminar and a very important one. I am delighted to be able to introduce you to Reiko Kato, who is a graduate of the William S. Richardson School of Law. And I'll note on her resume, it says something like research assistant for Mark Levin. So I'm really all the more happy to have Reiko here. But Reiko didn't start as a research assistant for Mark Levin. Her legal studies started at Hokkaido University in Sapporo, Japan. And she obtained a Bachelor of Law there and then came over to the United States and got an LLM, which is a post-graduate law degree at the J. Reuben Clark Law School in Provo, Utah, in the Masters of Comparative Law. Reiko spent a number of years in various activities in both Utah and in Hawaii, coming to Hawaii around 2000 and moving to Hana. That's a pretty good choice. And made another good choice to be one of the first students when the Richardson Law School established an AJD program. So AJD stands for Advanced JD. And the idea is that students who have already studied law abroad can obtain some academic credits for their earlier study in law in seeking a JD at our law school. It's a very challenging program because the JD is hard enough, but this now calls upon the students to obtain a JD in just 2 years instead of 3 years. And again, Reiko was in our inaugural class and graduated with a JD from Richardson Law School in 2016. She clerked for Judge Bisson at the Hawaii State Second Circuit in Maui and worked in a number of jobs as well as starting her own business in Maui, but more recently took a position as a staff attorney at the Legal Aid of Hawaii. And noticing a few legal aid lawyers on our participants list, welcome to Reiko's colleagues who are here, including a few more Richardson alums there. So Reiko started this work while she was at Richardson, in part because the very important Supreme Court decision came down during her studies. And you'll hear more about it from her rather than from me. But it was clear that she was moved and determined to come to a better understanding of what had happened in that case and what was behind the case and what might be done. And Reiko has been working on this, most recently collaborating with Professor Etsuko Toyoda, who will be recognized as well, who is now an independent scholar, but at the University of Melbourne in Australia, to be understanding this. And at the end, we'll drop into chat. They have a paper coming out that will allow you to follow up if you would like to learn more. So with that, it really is my honor, my privilege, my delight to introduce you all to Reiko today and that we can all hear her talk. Aloha, Reiko.
Thank you very much, Professor Levin. Now I'll share my screen. So I really appreciate this opportunity to share this topic, marital surname system in Japan, with you today. Using this opportunity, again, I would like to express my gratitude to Professor Mark Levin for his support on this paper and the co-author, Professor Etsuko Toyoda, a retired professor from the University of Melbourne in Australia. I deeply appreciate their support on this presentation. The title is Marital Surname System in Japan, with subtitle Fufubessei Issues and Disparate Impact of Civil Code 750 and Family Registry Law. This topic often appears in Japan for gender equality issues. Japan's current system is unitary surname, means one surname per family. A husband and a wife must share the same last name. For example, in the US, if I marry to Mr. Mike Smith, I can continue to be Reiko Kato and I do not need to be Reiko Smith, changing my last name. However, in Japan, both spouses must have the same surname. So if I keep my last name Kato, then my husband needs to be Mike Kato in Japan using my last name. Japan's marital surname system has been criticized from other countries and also by the United Nations. The Japanese government has been told to change a discriminatory clause in the Civil Code 750 that prohibits people to retain maiden names after marriage. However, Japan has not achieved a law revision over 30 years because the court said the issue should be resolved by the legislature. On the other hand, the legislature says the issue should be resolved by the court. The judiciary and the legislature are catchballing the responsibility to each other. Japan's marital surname system cannot be addressed without talking about Fufubessei issues, ES system, which is a background cause of the issues in this topic. I also talk about disparate impact, that the Japanese laws cause unintended discrimination to its citizens. Then I will discuss about the marital surname related lawsuits, especially focusing on 2015 Japanese Supreme Court decision, which is highly criticized by scholars. Let's start with a section 1, Fufubessei. The word Fufubessei often emerges in headlines in Japan. What is Fufubessei? Fufubessei means a married couple to have different surnames. Current laws in Japan only allow to use one of the spouse's surnames. The marriage registration form only allows a couple to choose one of their last names. This is how the marriage registration form looks like in Japan, where the highlighted section is a section asking to choose husband's last name or wife's last name. They are required to checkmark only one of them. In this form, one spouse does not have a choice to retain his or her own surname. The problematic laws regarding marital surname system in Japan is Civil Code Article 750 and Family Register Act. In those laws, marriage is recognized only with the same family name. Koseki, which is family register, is created only under the same family name. Civil Code Article 750 states, a husband and a wife shall adopt the surname of the husband or wife in accordance with that which is decided at the time of marriage. So a husband and a wife can discuss each other to choose which last name they are going to use after marriage. The term of the law look like fair between husband and wife, but the problem here is that couples cannot marry unless they choose only one of their surnames. So some couples who cannot agree to one name must give up on getting married. As a consequence, the couple cannot enjoy the benefits that married couples have, such as tax exempt, inheritance, or even the children have disadvantage. The Civil Code Article 750 restricts the freedom to continue to use one's own names in Japan. This is how the koseki, family registry, looks like in Japan. Koseki is all about family, not about individual. In Japan, birth certificate, marriage certificate, death certificate are not separately issued like how we do in the US. Instead, all of those are recorded in the same family registry page of each household. Koseki form is issued for one family and all members are included in it. So please see this koseki form. At the top page of the form is head of the household with his or her full name, including the last name. However, the family members are listed below with only their first name. Because of course, in Japan, they all must have the same last name as a family. How about surname systems in other countries? In the most countries, a husband and a wife can keep their own last names. These on the slides are only a few examples how other countries deal with surnames. Each country has different style, but they all allow husband and wife to have different surnames. However, interestingly, Japan is the only country that does not allow different surnames for a married couple. Now, let's examine how the United Nations see Japanese marital surname system. Sedo was adopted in 1979 by the UN, United Nations General Assembly. Japan ratified the treaty in 1985. Then 1993, and since 1993, the Sedo Committee has been recommending Japan to change the discriminatory laws, the Civil Code Article 750, for almost every 4 to 5 years. I could not include in this slide, but additionally, in March 2020, Sedo Committee again requested Japanese government to provide information on action taken to adopt legislation safeguarding the choice of women to retain their maiden names upon marriage. This is a timeline for Japanese government's effort to comply Sedo. 1 year after 1993, Sedo's request to revise the Civil Code, Japan drafted for revision of the Civil Code, but it was turned down by the National Assembly legislature for review. 1 year after another Sedo's request in 1998, the government established a committee to deal with the issues. Then the government has been implementing new plans for each Sedo committee's request for every 5 years. However, the law has not been revised yet, almost for the last 30 years. It is probably obvious to see the problems here now. Japanese government craftily established new law, committee, and new plans to deal with the Civil Code revision, but never revised a revision for the past 30 years. Their excuses for not changing the law are: family unity is weakened, children are negatively affected, tsusho, alias, social use name is sufficient. Unitary surname system is an established system and tradition. Surnaming is not individual freedom issues. Public opinion is not in favor for dual surnames. It almost seems like Japanese government has been just pretending that they were working on the issues to comply Sedo's request, but they do not have intention to change the law. The marital surname issues are first appeared as a gender equality issues. However, now it is not only the matter of gender equality anymore, but also human rights issues. It applies to both women and men and any sex orientations. Both husband and wife's right to marry is infringed when a couple try to respect each other's wish to keep the same surnames. But there is no recourse for a wife and a husband to legally marry in Japan without changing one spouse's last name. Another example for this is in a business setting. Mr. Aono, who is a president and the CEO of Cyborgs Corporation in Japan, chose his wife's last name upon marriage. However, he continues to be known under his own last name, Aono, for his business. He experienced a difficulty in the current Japanese system because all his contracts were prepared under his previous name. He could not sign them because his name in the passport is his wife's last name. They had to rewrite all the documents to change his last name to his wife's last name for him to notarize a document. In this section 2, we will discuss about ES system. The background cause and reason of Japan's marital surname system issue is ES system. We will examine the ES system in chronological order, Meiji era, post-World War II, and present how the ES system affects Japanese society now. So what is ES system? Ie literally means house. This ES system is a moral education influenced by Neo-Confucianism. Confucianism is originally from China to emphasize family hierarchy and respect to the senior member of the family. This Japanese New Confucianism relates to modern revival of Confucianism. It is not ancient nor tradition. It is reinvention of Confucianism. Meiji government aimed to establish a national family with Tenno, emperor, as a head in the pyramid, and the government as senior members to control the citizens down below in the pyramid. ES system was introduced in Meiji era. It is not a Japanese tradition. Japanese government uses this ES system as an excuse not to change the civil code by saying ES system, the current unitary surname system, is Japanese tradition. However, ES system is not a Japanese tradition. It was just implemented to the governmental system in Meiji era in 1896, a little over 100 years ago. Its purpose was to headcount citizens for drafts for wars, for performing the census. Commoners never had their own last name before that. I inserted some of the sections of Meiji Civil Code here. Article 747, family head had absolute legal authority over all family status. Article 746, all family members were required to take the same surname. Article 970, hierarchy followed a strict succession order of male over female, old over young, legitimate over illegitimate. Article 750, a female family member to be married out at the discretion of her father. So the woman has to have father's consent to marry at that time. Article 14 to 18, once married, a female becomes a person of legal incapacity. Article 788, a female was required to change her surname to that of her husband's household, wherein she became a new family member. So Meiji Code requires a wife to adopt a husband's last name here. This discriminatory ES system was abolished after World War II by the new constitution. Accordingly, the previous Meiji Civil Code was eliminated. Thus, the current Civil Code no longer requires a wife to adopt a husband's family name. So the current law seems to achieve gender equality, but it does not. I will explain this in the following slides. Even after legally abolishing the ES system's customs and attitudes still exist in Japan now. Currently, in Japan, it is a wife who changes the surname in most marriages. Rate of wife adopting the husband's surname is over 96% since 1970s, at least for the past 50 years. However, the public opinion has been changing more in favor of dual surname system. The recent government opinion polls show supporters of changing the current system are increasing to 42% now. I included private sector opinion polls as well, because the government opinion polls are often tampered a little because of government polls tend to use more elderly citizens to have favorable result for the government. The older people are more anti-dual surname because they grew up with that ES system I just explained. So according to the private section opinion polls, in each newspaper survey, majority of the people, up to 67%, almost 70% of the people are in favor of changing the current system in favor of selective dual surname system rather than current unitary surname system. Compared to the government polls, the private polls have 30% more people support to change the current system. Koseki system functionally preserves the ES system. Koseki, family registry, does not help to completely abolish the ES system from people's mind and customs. Because it includes such family hierarchy, Koseki is preserving the ES system. ES system has been functionally preserved, especially in rural conservative areas. Professor Toyoda's interview study in 2020 shows that in such rural areas, IE is important system, family lineage. Daughter is educated under ES system. Man would be socially inferior if the family does not use his last name. Therefore, recently the change in the subject civil code has been brought up to the court as Fufubessei lawsuits and lobbying, and also more awareness for law revisions. In the next slides, I will introduce disparate impact theory that would be suitable to be considered in such circumstances present in Japan. Disparate impact theory was first introduced by the US case Griggs versus Duke Powers in 1971. Generally, to prove that discrimination requires the perpetrator's intent and motives. However, under this disparate impact theory, discrimination occurs not only by intent, but also by unintentional policy and practice without proving intent to discriminate. These US-originated concepts are also accepted in other countries. Japan can utilize this theory in marital surname system as well. Japanese civil code and family registration law mandate to choose one surname. They are facially neutral law without the presence of discrimination, but it does give discriminatory impact because 96.5% women take husband's name due to the preserved ES system. So Japan should consider disparate impact on people caused by the Civil Code 750, even though they did not intend to discriminate by the laws, since the law are fair to both spouses. The three-pronged test of disparate impact was introduced by the 2050 US case. 1, plaintiff must have prima facie case drawing out the explicit causal connection between the policy and practice and the disparate impact. 2, defendant has a burden of proof that policy is necessary to achieve a valid interest. 3, if defendant meets his burden of proof, then plaintiff must show there is an available alternative practice that has less disparate impact and serves the legitimate needs. We are now coming back to Japanese case. Marital surname lawsuits in Japan started from 1988, and the most recent is 2021, last year. From this slide, we will focus on the Fufubessei lawsuit started in 2011 and concluded in 2015 by the Supreme Court decisions. In 2011 lawsuit, plaintiffs are de facto marital relation couples. They brought this suit to challenge the constitutionality of Civil Code Article 750 for violation of Constitution Article 13, 14, and 24. Plaintiff argued that the Civil Code 750 is a violation of constitutionally protected rights, right to choose own surname, not to be forced to choose surname, equal treatment between husband and wife under the law, and right to marry, plus the violation of UN CEDAW Treaty. Defendants, the Japanese government, on the other hand, responded to the complaint stating such specific rights for dual surname system are not protected under the Constitution. The CEDAW Treaty is not self-executing, so it would not apply to this case. Now we discuss about the Supreme Court decisions. Supreme Court reached a decision for each constitutional right brought in this case and ruled the civil code in question is constitutional, which means plaintiff lost the case. I will explain its decision divided into 3 rights protected by the Constitution here. Freedom not to be forced to change one's surname, the right to be treated equally between husband and wife, the right to marry. First, for the freedom not to be forced to change one's surname, Article 13 states all the people shall be respected as individuals. The court agreed the names are part of jinkakuken, which means individualness. However, the freedom not to change surname is not jinkakuken, the court said, because such specific rights are not enumerated in the Constitution. The court more focused on the importance of the family as a unit of the society and couples' position in the society. Secondly, for the right to be treated equally between husband and wife under the Constitution, Article 14 and 24, Section 2, the court ruled the law provides equality because the terms of the law do not explicitly discriminate based on genders. The spouse's mutual consent results in the women choosing the husband's surnames. In other words, the court said Civil Code Article 750 does not discriminate one gender on its face, like how Meiji Civil Code was. If you recall, Meiji Civil Code specifically said that wife must adopt her husband's last name, right? Finally, for the freedom to marry under the Article 24 of the Constitution, the court said the right to marry is not violated by Civil Code because the law only regulates surnames, not that marriage. The court also said the law should be regulated by current social and family values. The unitary surname system is rational because it has been the tradition. Tsusho, alias, or commonly used name would be sufficient, and it should be discussed in the National Assembly. In other words, court used the same textualism. The law only said about surname, not the marriage, so it does not infringe the right to marriage. The issue should be discussed in the legislature because it is a matter of public opinion. In sum, Japan Supreme Court in 2015 upheld constitutionality of Civil Code Article 750. Supreme Court ruled the surname law issues to be discussed in the National Assembly. However, there is strong opposition within the ruling party, as we discussed earlier, that the government is so reluctant to revise the Civil Code. Now, I would like to introduce dissent opinions. The Japanese Supreme Court is composed of 15 justices. In this 2015 decision, 5 justices oppose in full or in part. All the women justices, 3 justices partly opposed to the decision. These pink-colored names are the women justices: Justice Sakurai, Justice Okabe, and Justice Onimaru. Justice Okabe, who is one of the 3 justices in the Supreme Court, disagreed with the decision for the constitutionality of the Civil Code Article 750 and pointed out that our current age is quite different from the time the Civil Code was revised in 1947. The other 2 women justices joined Justice Okabe's opinion. She also pointed out that Civil Code 750 presumed that a family consists of married husband and wife and the children born from them under the same last name. However, law recognizes an exception. For example, Japan allows a couple of international marriage that one spouse is a foreign citizen can retain their own last names. And the law recognizes such couples as a family even though they have different surnames. Justice Okabe also said common usage of maiden name is not working out because it is not legally registered in the family registry. Judge Kiuchi opinions not allowing the dual surname system is violation of Constitution Article 24. He pointed out that government and the court only focus on whether unitary surname system is rational. However, the real question should be whether it is rational not to allow exceptions to the unitary surname system. Not allowing to have exception to the current system is irrational. He also pointed out using the commonly used name for substitute of dual surname system is defective because it requires employers' permission to be able to use a commonly used surname in the business setting. Judge Imaura stated that Japanese government has known that change needs to be done since 1970s. The government has recognized the disadvantage of the current system due to the change in the social structure over the years. They know about the legislative movement for selective dual surname system to revise the civil code since 1990s. Plus, the CEDAW has been repeatedly requesting the civil code revision, and Japan is the only country that does not allow the exceptions to the unitary surname system. Here is the analysis to the Supreme Court decision with each court reasoning for not revise the civil code. Court reasoning 1 is surname is not jinkakuken because it is not protected under the Constitution. However, in my opinion, Supreme Court has already recognized the full name as jinkakuken in Hoppo Journal Jiken in 1986. Court 2, surname is to identify the family as a basic unit of society. However, the court is prioritizing social norm and family unity over individuals, even though the Constitution protects individuals. Nowhere in the Constitution state it protects family. I think Professor Levin pointed this out. Court's reasoning 3, Civil Code 750 regulates surname, but does not regulate marriage. However, Civil Code basically restricts the right to marry because many couples cannot legally marry. The current law does not provide any remedy for couples who need to or wish to retain his or her own last name. Court reasoning 4. Public opinion has not reached to change the system yet. However, as we discussed earlier, the public poll and private sector opinion poll indicate a majority over 67% of citizens are in favor of changing the current system. Court reasoning 5. The current unitary surname system is rational because it has been rooted in Japanese society. However, as we discussed earlier, unitary surname system is a system that introduced by the Meiji government. It is not Japanese tradition. Court reasoning 6. Allowing to use a maiden name as common usage is enough to ease the burden in difficulty to maintain the social trust and honor they have earned. However, it is not legalized. Thus, using maiden name as a common username will cause serious defect. Please recall Mr. Aono, the company president case, that he could not notarize an important contract document with his ID. Court reasoning 7. The Civil Code Article 750 is facially neutral and not discriminatory. However, Civil Code Article 750 imposes disparate impact. We can use disparate impact theory here. The law looks fair for both spouses, but in reality, over 96% women choose a husband's last name, and some experienced discriminatory effect not treated equally between men and women. The government did not prove that the change is not necessary because its reasons are family unity, social norm, public opinion, unitary surname as Japanese tradition. The Civil Code revision that provides the choices to allow spouses to retain their own last name will be a great alternative to protect the rights of the people. Court reasoning 8. The Civil Code is constitutional, so this issue should be discussed in the National Assembly. However, it should be ruled by the court to determine the unconstitutionality of the current law, to force the legislature to revise the Civil Code Article 750. The court should not send the issue back to the legislature because the ruling party does not have intention to work on the revision according to the past history, how they dealt with this issue. The ruling party, Liberal Democratic Party, preventing the revision draft to submit to the legislature. When CEDAW requests to remove the discriminatory law, the government only pretends to be working on the issues by showing they have implemented new divisions for gender equality and plans, and governments do not change the law by reasoning that public opinion has not reached to change the law. The government has more excuses such as unitary surname system, Japanese tradition, or revision was caused to weaken the family unity. However, those are not good reasons to postpone the Civil Code revision. I listed 3 possible solutions. Solution 1 is to issue a marriage certificate instead of just registering in the Koseki family registry. Issuing an official marriage certificate separated from Koseki would be an alternative solution to give choices to couples who cannot register their marriage due to Civil Code restriction. Solution 2 is to revise Civil Code Article 750 and give a choice of surnames by applying the selective marital surname system into Civil Code Article 750 and adding a clause, the husband and wife continue to use their surname in Koseki. This is probably the most possible solution because all they have to do is to simply add one more choice in the marriage application form. Solution 3 is to relinquish Koseki system. Because Koseki has been criticized by many scholars as a discriminatory system, Civil Code Article 750 and Koseki closely linked together. Other countries have changed from unitary surname to dual surnames. Koseki preserves a system that government was to abolish after World War II. In conclusion, the Civil Code Article 750 infringes the constitutionally protected rights, so it needs to be revised. I was born and raised in Japan until my 20s, and I did not know about this issue when I lived in Japan. I was taught to walk 1 foot behind the husband. I thought taking the husband's last name is how it's supposed to be when people marry. None of my friends and relatives would question that. I was a frog in a well. Perhaps due to the perpetuating ear system in Japan. I now live in the US, and I am fortunate that I can see Japan through the lens of other countries. The Liberal Democratic Party has been the ruling party in Japan since 1955, except for a few occasions. The Liberal Democratic Party has been making so many excuses not to give exception to the current unitary surname system over 30 years. At this point, pushing the responsibility of civil code revision back to the legislature will not go anywhere. Disparate impact theory has been accepted by many other countries to prove that government policy unintentionally discriminating citizens. The Japanese court must take this issue more seriously to determine the law's constitutionality through disparate impact lens, remembering the court is there to protect the people's constitutional right violated by the government. Just closing eyes to the issue, removing people's choice to enjoy the rights they are supposed to have, is not rational. The selective dual surname system through the law revision would not force everyone to use their maiden name, but provide a choice to married couples to use either one surname or dual surnames. I believe the consideration of disparate impact on people will open up the Japanese judiciary's eyes, and the court will mandate the legislature to revise Civil Code Article 750 to eliminate a discriminatory clause. Thank you very much.
So thank you, Reiko, and that was outstanding. And one of the things about webinars is you don't get the applause that you would have in a room. So we're just gonna, oh, I see some applause popping up. So somebody knows how to do that. So with that, Reiko, we've had some questions pop in, and let me go to them and share them with you. First, this is great, yeah. And the first one is not a question, it's just one of our guests had to leave and wanted you to know how much she appreciated what you were doing. Next is from Natalie, who said, do you think this issue could extend to same-sex unions in the future in Japan?
Yes.
Or, you know, in the relation, sort of how do you see the implications of this might fit into that movement which is happening in Japan now, essentially in parallel or in tandem with Fufubessei?
Yes, I believe it will be extended to same-sex union in the future in Japan as well, because it was originally started as a gender equality issue, discrimination against women. However, as I explained in the slide, it's transitioning to the issue of the human rights issue. It's not a matter of between men and women, because the issue is they have to choose just one name, even the husband and wife, even for the same-sex unions. I hope I explained that well enough. Sorry.
Oh, that's great, and I think it is an interesting set of dynamics. I sort of see it a little bit like two shoelaces that are tied together, and as one loosens up, the other one may be loosening up as well. And with the registration, Tokyo just opened up, I think this week, allowing for same-sex partnerships to be registered. That people sort of hopefully become more comfortable with, or I should say more people become more comfortable with fluidity in family structures. Professor Greeny has a question here, and it says, there is already an exception when a Japanese woman marries a foreign man, and vice versa, by the way. In that case, the Japanese spouse stays in their koseki, and the foreign spouse and children are added. And that takes place even if the children take the foreign spouse's names. So do you know if the woman takes the husband's name, so I should say if the Japanese spouse takes the foreign spouse's name, wouldn't that, how I guess, let me take this over. How do you see this exceptional circumstance of Japanese nationals marrying foreigners affecting this discussion?
Yes,
Does
so
it?
it is possible. It is possible that if a Japanese, for example, if a Japanese woman married to American citizen and she would like to be recognized under her, foreign husband's last name, she can create her own koseki as she is a head of the household.
So in essence, this is a more liberal structure, and does it demonstrate the possibility that could be
It is
equally
possible.
applicable domestically?
However, dual surname is not allowed in that situation because she chose to create that new koseki with, as she is a head of the household with foreign last name.
Okay, thank
Yeah.
you. Professor Ito, who, like you, graduated Hokkaido University, by the way, has a comment. And she is looking at these circumstances in Japan where essentially there's an eldest daughter of a family, and there are no boys in that family to take on the family name, right? So you've got there's only daughters, there's no boys getting married. And so that was or perhaps still is a common current occasion where the man in a marriage would take the wife's name, the husband in the marriage. Do you know if that is still happening? And how do you think that shapes the discussions around this issue?
So I believe it still exists. We call it mukoyoshi. Instead of women marry into his family, he married into her family. In this situation, he takes his wife's last name. However, if this situation happens, occasionally, quite often, there's a discrimination against mukoyoshi, the husband who took the wife's last name.
So
But
in essence,
yes.
the husband who would do that might find others looking askance at him in the social structures because of these pressures.
Yes, I think so. The yes system, the main idea is like a family hierarchy, and based on the Meiji Civil Code, elderly over young, older old over young, men over women. So in that point of view, mukoyoshi seems, people tends to treat poorly in that kind of mukoyoshi situation.
And if I can follow up from that before moving on, can you talk a little bit about Professor Toyoda's work, and are these, to the extent that these dynamics may be different based on whether or not the couples are in major metropolitan areas or in more rural or less central metro cities.
Yes, Professor Toyoda's interview study that distinguished from rural area and metropolitan areas. So she pointed out, especially in the rural areas trying to perpetuate the ES system, then if mukoyoshi happens, men married into wife's family, would be socially, treated socially inferior because, he could not use his last name after he married.
Great,
Did I
thank
answer
you.
your question right?
And we should note that we had hoped for Professor Tsuyoda to be on today's conversation. Her
Yeah.
personal circumstances called her away, so we were sorry for that. But perhaps we can get her here and follow up with a part two. She, am I correct? She's a linguist in her scholarly background, sociolinguist.
Yes.
Are you, right? And so her perspectives, her investigations are complementary with yours, and that may be evident in the paper, but perhaps it also allows a different angle on exploring these questions. We have an anonymous question, but it's a good one. And that goes to trying to, in essence, to assess the weight of the different factors that may be impeding change, right? So as you discussed, there's a lot in the picture. The question asks how should we be, which you think might be most significant, because that would be where to address perhaps how to accomplish change. Comparing, for example, the government's simply a bureaucratic reluctance to change the system because it's going to be expensive or they don't know how to do it, right? So this institutional set of reasons as compared to the social reasons. If you were to say which factor between those or of other circumstances are the biggest drags on change, how would you read that? Why do you think, what is the biggest problem that seems to be impeding, blocking change?
Right now, I think the Liberal Democratic Party, and they are, sorry, and they are using the ES system as a reason, and they try not to change the system currently placed in Japan. And unfortunately, probably Japanese people are not well informed, and they probably need to be more informed and understand what's really going on in their own country.
And I'll add there, and you and I have talked about this, that to a certain degree, the litigation may well be a positive force in that sense, that at least for law students, right? When you studied law, I'm guessing Fufubessei may not have been part of your constitutional law coursework, but precisely because these cases are going to the Supreme Court, currently at least law students will be introduced to these issues and thinking about it. Or does that seem right to you?
Yes. Thank you, Professor Levin.
So yeah, we could both make trips back to Hokkaido University and sit in on the constitutional law class and raise our hand in these discussions. Brandon Higa, another Richardson student, has posted, and he wants to again take this back to issues of sexual minorities and the extent that their relationships are delegitimized by the Koseki system, right? So if you, it's the Koseki system simply does not have, under its current structure, have any space for couples who are in same-sex relationships. So first, Brandon wanted to express your thanks because his thanks, because he believes that your analytical framework provides a map for all disenfranchised couples to litigate. But he's asking then about localities. And perhaps this goes to the idea that now some localities in Japan are allowing recognition of same-sex couples. Do you think that there's maybe a mechanism where localities could at least liberalize their treatment of married couples, for example, with aliases? And how much value do you see in the alias system as an alternative to formal recognition? Do you think they're equivalent?
ABS is probably just a temporary solution, and it will not legally help them, as I explained in the slides, because alias is not going to be on their ID, especially on the passport.
So thank you. And also two other things that might be noted. One is that there is now a justice at the Supreme Court who is a woman justice at the Supreme Court who is carrying on her work using a marriage alias, which certainly suggests her strong values on this. And folks, I'm buying time. We're open to more questions. So anyway, I think that's indicative of the potential for change. People may or may not know that Japan's Supreme Court changes its personnel relatively quickly, certainly compared to the United States. So am I right, Reiko? Are any of the 5 dissenting justices still on Japan's Supreme Court? Maybe not, from the 2015 decision?
I don't think so.
Right? So none of them are there. So for members of the audience who are accustomed to the United States, where our Supreme Court justices serve for decades, typically, in Japan, because of the rapid turnover, appointments typically in one's early 60s and a mandatory retirement age at 70, you don't have that ever. But what you do have is sort of a new generation of justices, and perhaps there may be some change coming from there. More questions, more comments? Folks, if it's easier to ask a question by us getting you on mic, Tatsuki can help us. You can sort of type into the Q&A that you have a question or a comment, and then we can mic you. If you would like to share some comment, we'd ask that you keep them short and respectful, but that is feasible because I know sometimes just typing a question can be challenging to do. While we're seeing waiting for others to come through, Reiko, you had another suggestion in the draft of these slides, and in the interest of time, you very generously were willing to take it out, but maybe you can talk about that now, which is a 4th suggestion, the idea of Japan having a constitutional court. How about if you explain that for a moment?
Okay, so I suggested a constitutional court as one of the solutions as well, because as you see in the 2015 Supreme Court decision, that Supreme Court is not willing to see, what kind of discriminatory effect is caused by the Civil Code 750. And what I worry about the Supreme Court system right now, we have the research system, it might be part of the ES system. They are trying to, put it in the bureaucracy of the governmental system. Tenno as on top and government second, and all other systems under the government executive branch. So the necessity of the separation of powers, probably constitutional court might be very helpful if it could be separate from the bureaucratic system under the ES system, what they are running right now.
And again, Reiko and I have talked about this, and for some folks in the audience may not understand the meaning of a constitutional court, because we don't have anything like that in the United States, but an example is South Korea. So in South Korea, there is what we would call the ordinary courts, which rise up to a Supreme Court. So South Korea has a Supreme Court. And for all but constitutional cases, that's the process of the jurisprudence. With regards to constitutional courts, there is a separate court, in fact, in a separate location in Seoul with its own building, that only hears constitutional cases. But what makes it also different is that the judges who serve on the constitutional court are selected in a different manner. A few from the legislature, a few from the executive, a few from the judiciary. And so it ends up being very, very different from a Supreme Court, where most of the judges, even in Japan, are career judges. Many of Japan's Supreme Court justices served much of their career, even working for the government, on a dispatch. And so this is what Reiko is suggesting about this highly bureaucratic nature of Japan's Supreme Court. Oh, some more questions coming in. I'll get right to them. And so this idea of essentially bifurcating the courts so the constitutional matters are freed up from these bureaucratic judges, then enables a new court that might have a more progressive, closer to the people's view. And then I'm looking at the questions come in, and one here is JP is for new question, is wondering about whether or not this system implicates ethnic minorities and indigenous peoples in Japan. Do you know about that, Reiko?
I'm sorry, which one is a question you were asking?
So JP's question, whether or not there are issues in the surname system that affect ethnic minorities or indigenous people in Japan.
Oh, yes, I believe so. If whoever who has a Japanese citizenship, and those people apply to this, could be applied to these issues. I really didn't understand that question very well. I'm very sorry.
So I'm going to mention Tammy Bryant and Tatsuki. I'm not watching the chat so well, but if you can, Tatsuki was nervous because I jumped over a couple questions. And that was because I wanted to get to JP, who hadn't asked before. So thanks, Tatsuki, for sending me that in chat. But if you can drop in, or just, because only Tatsuki can chat. The author's name is Tammy Bryant, T-A-M-I-E-B-R-Y-A-N-T. And she has a larger piece that I know Reiko is familiar with that looks at the Koseki system overall. And then there's also been more recently some books on the Koseki system. And so for JP, the answer is there's this isn't at the center of Reiko's work, but there is work out there that looks not so much on the surnames, but the Koseki system's implications for ethnic minorities, indigenous peoples there. And then I'm going to skip up to Brandon, and he is asking if you know whether other countries have a Koseki system. And
Yes.
yeah, so go ahead.
So韓国, Korea, and Taiwan also use Koseki system. However, they use dual surname system, means husband and wife can have different last names.
So, and one of the things that I find curious there is that on the one hand, you'll often hear attributions to Confucianism, explaining why that Japan has this patriarchal system with male surnames high given priority, and yet certainly China, Korea, and Taiwan, all of whom have Confucian traditions, have somehow managed to get beyond that in how they recognize the surname issue. And then we have two more questions on foreigners or women marrying foreigners, or I should say someone, a Japanese national marrying a foreigner. And do you know if it's possible to start a new koseki with a foreign name? I'll be right there, Tatsuki. So do you know if it's possible for, if...
Yes, I read the Haruko-san, is that right? Yes,
Yes.
it is possible, because I am one of them.
So at an earlier time, Reiko had a different surname, and it was written, had a katakana spelling, and you had your own koseki with
Yes,
with that,
I was the head of the household and
with
created
a
my
katakana
family. Yeah, koseki.
non-kanji name. But again, that's the exception because of you having married at that time a non-Japanese. So that's how that can take place. That and then Anonymous asks about allowing couples where one spouse is not Japanese to retain their own names. And there again, the koseki system, I can speak from experience here, that I'm married to a Japanese national. I am not entered into the koseki as a part of the household per se. I am a footnote. So my wife has she's the head of a household. And then there are, our children are listed within the koseki, but since I'm not a Japanese national, I appear there as a footnote saying, well, she married that guy, is how the system reads. So they are very closely intertwined. And I hope that, I think that covers all of our questions, and I hope folks have felt answered. And Tatsuki just posted about Tammy Bryant. So Tammy, now her passion is animal rights, so don't be confused. You're not looking at the wrong person. But in the early 1990s, she wrote a brilliant article about the koseki system that I still teach from. And I'm going to trust people are skillful researchers to find it, or if not, you can reach out to our office and we'll be happy to try to assist you. Reiko, any final thoughts or comments on these issues and what you would like? So, well, let me ask you, among the solutions that you had, which would you wish for first, and what would you like to see?
Yeah, the second solution, I suggested the revision of the Civil Code 750, so that, they can just to add one more section to check mark for the choices to have dual surname. That might be a very simple way and the fastest way to achieve that.
So it may not solve all the issues associated with the koseki, but at the very least,
Right. It
it
doesn't
would.
have anything to do with koseki, but at least achieve the choice of the people.
The dual surnames for Japan.
Mhm.
Well, this has been fantastic. Tatsuki, maybe one more time before we go, if you can drop in the article that's available for download. And just for those of you who are not familiar with SSRN, it's the Social Science Research Network. It's an online distribution of both working papers and published papers. So Reiko and Etsuko Toyoda are developing this paper. It's posted now as a working paper, but it is available for open access, free download of the entire full text. So the article is available for you to read. And this has been fantastic. I'm so glad. This is a subject that I think has not had enough attention particularly in the English language communities of Japanese studies. And Reiko presented this at the Law and Society Association annual meeting virtually, but the meeting was in Portugal this summer and now today. And we really hope that you will continue with it because it is important for people to know about it. Reiko, any last thoughts or comments?
Oh, I just want to say thank you very much for the opportunity to share my paper, a preview of my paper.
And we thank the audience for coming and sticking around because we know people have places to go and things to do. And if you are free at 3 o'clock, come on down to the law school or click in and hear our second. You'll see me again introducing Professor Potter. It's a great day. I'm very, very fortunate for that. Reiko, that was wonderful. We will thank our audience and welcome you to come back. Our next CJS event, Tatsuki, help me out here very quickly. It's going to be, we have a campus only event happening on November 10 for our campus community. And we've gotten the word out about that. And then our next open seminar will be mid-month. Am I remembering correctly? November 16? And relating to, we're moving away from the law and we're going to be looking at Japanese theater. And it may not be precisely the 16th, but somewhere there. There it is, November 16th. Nailed it. So there you go, everyone. Come back and join us on November 16th. And follow us on social media so you know so we'll absolutely keep you informed. Okay, aloha, everyone.